Good afternoon, good evening. My name is Patricia Viseur, and I will be moderating our panel this afternoon on reclaiming the codification of the international crime of the slave trade. I would like to say that reclaiming the codification of this international crime is seen within the context of the pursuit of reparatory justice and racial justice. Today, I'm going to be joined by some excellent panelists. I would first like to thank very much our co-sponsors, and they are the Emergent Justice Collective and also the Cardoso Law School Institute of Human Rights. And I'd like to give a special thanks and shout out to our artist, the designer of our background, Gabby DeLuca, as we can see that we are among the waves and the water moving in the ocean in the background design. If you would permit me now, I thank the audience for being here, and I thank our two panelists. The first panelist is His Excellency, Dr. Michael Imran Kanu, who serves currently as the Ambassador and Deputy Permanent Representative for Legal Affairs at the Permanent Mission of the Republic of Sierra Leone to the United Nations in New York. In that role, Dr. Kanu coordinates the African Group in New York on the ongoing negotiations of the Intergovernmental Conference on the International Legal Binding Instruments under the United Nations Conventions, such as on the law of the sea. And I have to say that the Ambassador and Deputy Permanent Representative has been very present and active in the negotiation of the proposed Crimes Against Humanity Treaty and the recent MLA treaty that is up for discussion last week in Ljubljana in Slovenia. I'd like to now turn to our second panelist, and it's Dr. Catherine Namakula, who is a member of the UN Working Group for Experts of People of African Descent. She's also a senior lecturer at the University of the Free State in Bloemfontein, South Africa. She's a professor in human rights and in criminal justice with the Global Humanistic University in Curaçao. And she's published extensively on international criminal law. And I'll have to say that, Catherine, if I may, Catherine, you've been quite a keen observer on both the positive aspects and the not so positive aspects of international criminal law. I welcome both of you here today. If you would allow me, I would like to continue to say that I, Patricia Sellers, I'm the special advisor for slavery crimes at the Office of the Prosecutor of the International Criminal Court. I'm also a professor of law at the University of Oxford. In the past, I've worked at the Yugoslav Tribunal and at the Rwanda Tribunal. So international crimes, and in particularly international crimes that look at evidence of sexual violence, have been part of my daily work. But within those crimes of sexual violence, we come across crimes such as enslavement and crimes of the slave trade. Today, we'll be speaking about the slave trade, the international crime of the slave trade. I first have to give the caveat that I am speaking in my personal capacity. I am not representing neither University of Oxford nor the International Criminal Court, and not the Office of the Prosecutor. To return to the crime of the slave trade, I would like to just set the legal scenery before we turn to our panelists. The slave trade is one of two crimes, the other being slavery and enslavement, that are part of the 1926 Slavery Convention and the 1956 Supplemental Slavery Convention. Usually when we talk about reparations, the issue is about slavery. And that's why we feel it's important to bring up the issue of the slave trade as being that second crime that goes within a discussion of reparations. The reparations that the Permanent Forum has been discussing during the past week relate to historic reparations for slavery, and I would add for the slave trade. But our discussion today is to bring international criminal law in its contemporary format and to discuss issues around the slave trade and possibly to question the absence of the slave trade as a provision in any of the modern courts or tribunals that right now are justice mechanisms for international criminal law. Maybe we should start with what is the slave trade? I believe in our minds we have this notion, and thank goodness we have our graphic, that the slave trade was a transatlantic slave trade, the slave trade of ships over the ocean. Of course, there was the Arab slave trade or the East African slave trade that went into the Middle East and even into India. I would like to specify that the definition for the slave trade is much broader than one would imagine. The slave trade entails basically three types of acts. The first is any way that a free person is reduced to being an enslaved person. However that mechanism occurs, whatever disposal has occurred to turn a free person into an enslaved person is basically slave trading. Also, when an enslaved person is then reduced to another situation of enslavement, possibly under another owner, possibly in another geographical location, that too is an act of slave trading. And lastly, the transport, transfer, or any movement of enslaved persons to different locations is an act of slave trading. So therefore, slave trading is much broader, much more complex, and I would unfortunately say much more ordinary, much more everyday than the big ships that went across the Atlantic Ocean during the 14th, 15th, 16th, and 1700s. One could envision today that the slave trade is when you have child soldiers who are enslaved, who are merely transferred to another unit. The enslaved child is now transferred to another situation of enslavement. Enslavement today could be the Libyan migrant coming from sub-Saharan Africa through several posts of migration, where in essence they've been reduced to slavery, moved from being a free person to an enslaved person, so therefore slave traded. I would like to insert this modern, not concept or notion or law. It's modern because the slave trade seems to have been forgotten. Unconscionably, it has been an omission in our modern courts and tribunals. And this is part of the root of today's discussion. How could we go from understanding that the slave trade is basically the forerunner, the precursory act of slavery, and an act that many slaves are subjected to throughout their life, to now omitting it? It is not present, and it was not present in the Rwanda statute. It was not present in the Yugoslav statute. It was not present in the Special Court for Sierra Leone statute. And it is not present today in the Rome Statute, which governs the International Criminal Court. There is no provision for the slave trade, either as a crime against humanity, nor is there a provision for the slave trade as a war crime. I will just conclude on one note to start our conversation, and that is slavery and the slave trade historically have taken place during periods of armed conflict. As a matter of fact, some armies were actually staffed by the imposition of slavery on persons, therefore reducing persons to be members of an army as slave trading. Slave trading was so common that it was used to gift children to other slave owners, or it was used as a bequeath. Within the United States, the nation from which I am, and as a member of the diaspora, slave trading, slaves were one of the few property that Southern women could own. They often couldn't own land, but they could own slaves. And therefore, as they married, they would take this property of slaves into the marriage and transfer that property to their husbands. That's a form of slave trading. So today, as Ambassador and Deputy Head knows, Sierra Leone has proposed that there be amendments to the Rome Statute and that there be provisions of the Crimes Against Humanity proposed treaty and the Mutual Legal Assistance Treaty that directly, expressly include the slave trade. So if I may, first of all, call you Michael. Michael, I would like to turn to you first and ask, I think the preeminent question is, why is it important for Sierra Leone to have taken this step to propose amendments to the Rome Statute of the International Criminal Court, as well as to the Crimes Against Humanity Treaty and the Mutual Legal Assistance Treaty that include the slave trade as an international crime? In essence, this is the move to codify the slave trade in our modern manifestation of international criminal law. Yes, we'd like to hear from you, please. Oh, I think you're on mute, Michael. I'm going to mute myself, but we'd love to hear you.
You know, after several years of, or at least 2 years of COVID and virtual meetings, so there's no virtual platform without you're on mute. So just a kind reminder. But let me thank you really for, firstly, the very kind introduction, certainly the important question, and for your important work. I also want to thank the hosts and sponsors of this event. I think it's a timely event, and so distinguished representatives, delegates, colleagues, ladies and gentlemen in this meeting. I would say it's indeed a great honor for me to join, and I have my eminent co-panelists in this, what one would describe as really an historic endeavor. And I think you rightly place it as reclaiming the codification of the international crime of the slave trade. And we see this as part of the effort to pursue reparatory and racial justice. I would answer the question, but let me start on a more solemn and somber note. Generally, the slave trade represents a horrific tragedy of humanity. You've given reference and indication to when you refer to the slave trade, the picture is the transatlantic slave trade, where more than 12.5 million Africans were held captive, and sadly typifying the horrific tragedy. Now, there is a connection between the transatlantic slave trade and Sierra Leone. At the abolition of the transatlantic slave trade, the emancipated slaves were reparated to what was then called the Province of Freedom, which is now modern-day Sierra Leone, and more particularly the capital, Freetown. The formerly enslaved Africans settled at a site which is basically the site of the historic symbol of Freetown, that is the cotton tree, and that was in 1792. This historic symbol of freedom and Freetown, which may have been perhaps 250 to 500 years old, sadly fell last week on the 24th of May, following a heavy rainstorm. Now it's the only lower part of the enormous trunk that is still standing. And to us, this is a huge loss to the city of Freetown and the people of Sierra Leone. And we really see the cotton tree as this symbol of freedom and the connection to the transatlantic slave trade. Now, if I should move to your question, Professor Sellers, I will offer two fundamental points on why it was important, and it is indeed important for Sierra Leone to propose amendments to include the slave trade as an international crime in the Rome Statute, and also the discussions on the proposed Crimes Against Humanity Convention in the Sixth Committee, and as well the proposal or the suggestion we made to the core group and the supporting state that recently adopted the MLA Treaty, that is the Treaty on International Cooperation dealing with the core crimes, even though we were just an observer member. Now, the first point is the historical nexus. Sierra Leone and Liberia were the sites for the repatriation of the freed slaves at the abolition of the transatlantic slave trade. And Dr. Sylvie Diouf has once reminded us at the United Nations when we organized a side event sometime in the past of the unique position Sierra Leone was subjected to and held in the horrific tragedy of the transatlantic slave trade. She noted that Sierra Leone, and I quote, was at the confluence of several migratory movements. It was a place of departure, a place of return, a place of exile, a place of refuge, and hence called the province of freedom. And so the government of Sierra Leone places really high value on this historical nexus. And it really is committed to take the lead to drive meaningful and constructive engagement on addressing the consequences of the slave trade, but also the egregious offshoots, racism, xenophobia, and the rest, and to pursue racial justice. So that is the one part and historical point which has to be made. Now, the second point relates to, and I think in your opening, this relates to dealing with the modern consequences of slave trade. And this relates to our principal commitment to ensure accountability for international crimes, including the core crimes, so genocide, war crimes, and crimes against humanity. Our recent transitional justice history has really consolidated what is our constitutional foreign policy, and really successive governments have demonstrated this will to ensure accountability for atrocity crimes. The Special Court for Sierra Leone was created by a treaty between the United Nations and the government of Sierra Leone in 2002. This was based on a request by the government of Sierra Leone. This is part of the two transitional justice mechanisms that we had, the Special Court and the Truth and Reconciliation Commission. Now, the court was authorized by the United Nations Security Council Resolution 1315, and it was established with a view to address impunity following widespread atrocities perpetrated during the protracted civil conflict, which ended over 2 decades ago in Sierra Leone, and also to ensure that those who bore the greatest responsibility were brought to justice. I'm really pleased to inform that there was justice for the victims, Special Court for Sierra Leone, which had many firsts in terms of the novel jurisprudential contribution to what was then the development of a nascent international criminal law and justice jurisprudence. So, for example, as part of the many firsts, it was the first international tribunal to recognize the new crime against humanity of forced marriage as an other inhumane act. This significant new legal approach in the investigation, prosecution, and conviction of individuals for forced marriage as a gender-related violation of international criminal law is a legal legacy of the Special Court, which really the government of Sierra Leone holds in very high regard, and we deem as important to pursue at a global level. The transfer of the so-called bushwives, as you've explained in that context, is basically slave trade. In the pursuit of our commitment for accountability, the government was quite receptive to the discourse and the work that has been done by institutions and individuals, including yourself as moderator, but also my colleague, eminent speakers, to really close this accountability gap. And this relates to the Rome Statute, but also in other multilateral processes in terms of addressing slave trade. Now, the Rome Statute does not contain provisions for slave trade as a crime against humanity or as a war crime. Specifically, Article 7 of the Rome Statute omits the slave trade as a crime against humanity. Equally so, Article 8 of the Rome Statute omits provision for the slave trade as a war crime in international armed conflict, but also in non-international armed conflict. So for this Rome Statute legal omission, which really presently resolved into significant impunity gap, and as you have explained, when you take into consideration migrants held in situation in which money has to be paid for them to be released, teenage boys that are abducted into militias and have to be transferred from one unit to the next. These are all present realities of slave trade, which has to be addressed from the accountability point of view. There's also a strong connection to this so-called bushwife syndrome, where the bushwives are distributed from one fighter to the next, and as such, there's need to address and redress really the plight of victims and acknowledge that this has to be done from the Rome Statute, but also other multilateral processes which we're engaged in. Now, I will quickly pivot to the 2 weeks of negotiations which We had really fruitful discussion on the mutual legal assistance and the MLA treaty in Ljubljana. But that there is a missed opportunity in the sense that the suggestion and proposal that was made by the delegation of Australia was not taken up by the core group and supporting states. And this is really the concern we have in terms of the importance of the issue to Australia, that we do not miss an opportunity to address this impunity gap whenever we have the opportunity to do so. I'll come back to this issue, but then let me end in answering your first question by expressing the hope that in the other multilateral processes, that is the Rome Statute amendment process, but also the proposed Convention on Crimes Against Humanity, we will collectively come together and address this slave trade impunity gap. For us, the historical context and the commitments to ensure accountability for international crimes in the interest of the victims really compel our interest and leadership on the issue. And this is the reason why we'll continue to pursue the amendments in the several processes which are open to us. Thank you.
Thank you, Michael. It's very, how can I say, interpellant in French to understand not only Sierra Leone's relationship to the historic slave trade, but to understand that Freetown, the very notion that one could become free after being enslaved. I think that's something that we also have to hold dear in our hearts. But it is rather disheartening to understand that the slave trade is considered a jus cogens value, which is the highest international law value. States have ergo almost responsibilities if slavery is being committed on their geographical territory, or if they know of slavery, to prosecute or transfer to a jurisdiction at will. That we're talking about an omission that one would think could have been one of the first provisions included in the Rome Statute, or certainly in other statutes. And that's not just because of the fact that it is a jus cogens provision, but because it really governs a real harm, as you've mentioned. It really governs atrocities that are occurring today. Catherine, if I can turn to you, I'd like to know, what promise do you think codifying the slave trade into these modern statutes could give us as descendants of African people, but as members of humanity?
Thank you very much, Professor Sellers, for organizing this very important webinar. To our participants, it's a good evening from cold South Africa. I wish to thank and extend my thanks to His Excellency Kanu for his contribution and participation here, and also to the Africa Group for furthering the agenda of once again doing it for people of African descent and Africans by coming through with this very important proposal. Firstly, I also want to confirm, as His Excellency has already noted, that enslavement of persons and slave trade are a present reality for especially people of African descent. It's not only in the past, but we also see it today. He has given one example, and also we can give the example of what is happening in the MENA region and in the Middle East and Gulf states. There are even online slave markets where people are actually auctioned in reality. Right. To your question, Professor Sellers, I think criminalizing slave trade would establish a very clear offense with clear consequences. And I'm very sure we might have all looked at Article 7, 1C, that talks about enslavement, but also I refer to your broad description of slave trade that offers a broader framework that needs to be specific in criminal law if we are talking about that offense broadly. So I do understand why an amendment is still necessary. It would bolster our efforts that are now basically only based on human rights, because the challenges we are having with human rights is that it relies majorly on state commitment, which is also varied by notions such as cultural relativism that are really very broad. And also there is a real lack of clear consequences. So we would see criminal law coming in with that very stern position. Also very important to note, our dear participants, is that criminal law is very specific. It has specific approaches and goals. It's punitive in terms of being retributive as well. It's deterrent, it's preventive, it's reformatory. And now we are also talking about reparatory justice coming under criminal law. And these approaches would be added to our strategy against the inhumanity of slave trade. We also see that there is a very well supported infrastructure of the prosecution, especially of the International Criminal Court, against anything. It's a very well facilitated office. It can conduct investigations, well facilitated investigations. So we would have that entire machinery coming in to support states, such as Leone at the present time, and many others, to really advance a strategy against this inhuman act. So we have international resources being garnered against this particular tragedy. And also, I would say that in case of a verdict, as we have seen in some cases, then we have an international reparations regime. We have the trust fund for victims coming in to actually support the victims in a way, so that there is a whole infrastructure of support for persons that are actually victims or are victimized by this particular crime. Then the litigation, the criminal litigation of slave trade will build a jurisprudence. We've seen a lot of jurisprudence, Professor Sellers, what happened at the International Criminal Tribunal for Rwanda, what it did with the issue of rape, expounding the definition beyond what is ordinarily known as sexual acts to other physical acts of intrusion. So we are seeing that also supporting gender-based violence claims at the national level. So we would want to see also that tilt to the national level as well. We have previously seen a case in Mali of enslavement as well, which was dealt with by the ECOWAS court. So we would have international jurisprudence building into all those initiatives or creative approaches by states against slave trade. I thank you.
Thank you very much, Catherine. I'm going to insist on one of the points you just made, because without having a provision for the slave trade, either as a war crime or as a crime against humanity, there can be no investigation, there can be no adjudication, which means that there can be no reparations. And as you correctly point out, if there is an infrastructure that does look at reparations after atrocity crimes, why can that not be applied to the slave trade if it were an enacted provision? Well, my question just on the side, I want to ask you, do you think this would also influence the transitional justice mechanisms? Because Sierra Leone had one of the most successful transitional justice mechanisms. You're sitting in South Africa now. And of course, the slave trade is not brought up in transitional justice mechanisms. Do you have any thoughts on that?
Different countries have different approaches to their transitional justice. And this is influenced by culture and experiences and what it comprises of. So if it is an issue in terms of the underlying conflict, I would think that it would come up in the transitional justice processes as well.
Thank you very much. I'm going to return back to Michael, but Michael, before I ask you a more technical question, I wanted to say also that the Special Court for Sierra Leone is very well known, certainly among practitioners, for being the first court that really seriously looked at the crimes committed against child soldiers. I think it took a customary crime and basically expressed it, enacted it, so that it would have elements. And certainly we can see that is Sierra Leone's, the Special Court for Sierra Leone's initiative in terms of child soldiers, that within the Rome Statute and within the cases before the International Criminal Court, that child soldiers were actually adjudicating crimes committed against child soldiers has been normalized. So I would just look at that as another one of the highlights of the special court for Sierra Leone. That one certainly could have said 30 or 40 years ago, well, you can't enact that as a provision within a statute. But what I wanted to ask you is that what is the technical process right now that the Sierra Leone mission is trying to construct in order to make these proposals become a reality for the Rome Statute, the Crimes Against Humanity Treaty, and if possibly the MLA Treaty in the future?
Thank you so much. Firstly, I have to agree with you. When you look at the many first in terms of the jurisprudential contribution of the Special Court for Sierra Leone, and as it relates to the slave trade, certainly the so-called bushwife and the transfer of the bushwives from one fighter to the next is one example. Another important example is the recruitment of child soldiers and the investigation, prosecution, and conviction in that regard. And that is certainly linked to the other example, which I gave in my first answer as it relates to the slave trade. So those are really some of the compelling reasons why we're taking this on board. Now, to the more to your specific question on the technical process, and I think this is where the audience will have to bear with me, because I'm really going to go into resolutions and the statute, but then we have to explain this so that we understand what's coming up in the immediate future. I will start with the Ljubljana Hague Convention on International Cooperation, simply because it has been adopted. I must make note that this is really an important contribution and advancement in ensuring state-to-state cooperation at that horizontal level, and so we do appreciate the work that was done in the 2 weeks and in the period ahead of the 2 weeks by the core group and supporting state. The proposal that was put forward by Sierra was to ensure that we address the impunity gap at that level, but also there is an important opportunity which is open to states that are considering signing the convention. That is, when you look at the Article 4, the optional application of the convention, I think there's provision for states to add this in their domestic legislation, make the slave trade and slavery extraditable, and by this provision, they'll be able to investigate, prosecute, or extradite, and be able to apply this from that state to state horizontal level, and not just in the ICC context, which is vertical between states and the International Criminal Court, or even ensuring that it's complementary to the crimes against humanity, where in that multilateral process, we think there's a far more greater opportunity for Sierra Leone as a member state of the UN to ensure that we have that provision, and to ensure that we also have that seeming complementarity between these two important provisions. So not all is lost in the Ljubljana Hague Convention, and so we hope that state parties will take this on board and apply Article 4, which has been adopted. Now, outside of that convention, we have two important multilateral processes. The first is the Rome Statute amendment process, and the second is the proposed Convention on Crimes Against Humanity, for which we've had substantive discussions already in the first part in the 6th committee not too long ago in the resume session of the United Nations General Assembly, the 6th committee. On the ICC Assembly of State Parties process, I should note that we've been guided by the provisions of the Rome Statute itself, but also the resolution of the Assembly of State Parties that deals with the working group on amendment, two specific resolutions. When we examine the Rome Statute, we would refer to Article 121, specifically paragraph 1, which requires that a state party that is proposing an amendment may do so. So it's open to us to propose an amendment. We've passed the 7 years period, and the text of the proposed amendment has to be submitted to the Secretary General of the United Nations, who is then required, as per the statute, to promptly circulate this to all state parties. once we make the submission. We have not made the submission to the Secretary General yet. The reason for us not doing so is based on a resolution of the Assembly of State Parties, and I'll come back to it shortly. I also just want to note, because this may affect the timing, that paragraph 2 of Article 121 also provides that no sooner than 3 months from the date of notification, so once we notify, the ASP, the Assembly of State Parties, in its next meeting, which could be in December, it shall, by majority of those present voting, decide whether to take up the proposal. And this, it can deal with directly, or it could refer it to a review conference. Given the precedent and example, I think this is an issue which the Assembly of State Parties can take up without reference to a review conference. Before getting to that stage, we've been mindful to look at the Assembly resolution. It's ICC ASP 8-6, particularly in paragraph 4. This established the working group on amendment, and the purpose for this working group is to consider amendments to the Rome Statute proposed in accordance with Article 121, paragraph 1 of the Rome Statute. So therefore, the intention is that we'll have some discussions on the proposal within the working group on amendment. Further resolution by the Assembly of State Parties, that is the ICC ASP 11-8, and we have to look at Annex 2. And in its paragraph 7, it encourages state parties with proposal to notify the working group on amendment of the intention of the government to submit proposals in line with Article 121 to ensure that, of course, there's this deep discussion by state parties before eventually the circulation is done through the Secretary General. So what we have done as a delegation and government with the proposal is to write to the chair of the working group on amendment. We've given indication that we are submitting a proposal in line with Article 121, paragraph 1, but in line with the encouragement to submit it to the working group. We have done so, and we're grateful to the working group, but as well the Assembly of State Parties for circulating this to all state parties to the Rome Statute. And we also note that the chair of the working group on amendment, that is Ambassador Juan Manuel Gomez Obrero of Mexico, as well as convened the very first meeting of the working group, and this is slated for Tuesday, 27 June 2023. So this is now, it's happening, and the hope is that we'll be able to introduce the documents which we've circulated, including the proposed amendment and non-paper which explains the amendment. And as you rightly indicated, this is a use cogent norm, and it's rooted in treaty law and customary international law. And we hope that the discussion would be quite constructive, and the hope is that there will be a lot of supportive voice in the working group. Now, that's the one process. The next process is the proposal to convene a conference of plenipotentiary to elaborate a convention on crimes against humanity. This is based on the recommendation of the International Law Commission on conclusion of its work on the draft article on the prevention and punishment of crimes against humanity. This work is guided by the relevant resolution of the United Nations General Assembly on the topic. And in the main, there's one critical paragraph, that's paragraph 4, which requires that the 6th committee shall resume its session for 5 days from 10 to 14 April 2023, and for 6 days from the 1st to 5th April and 11th April 2024, in order to exchange substantive views, including in an interactive format, on all aspects of the draft articles from the ILC, and to consider further the recommendation of the International Law Commission. I must report that the first informal exchange has been quite substantive. It's a really robust engagement, interactive format, including mini debate. And within the discussions, the delegation of Sierra Leone expressed the view that not only we are supportive of the recommendation of the International Law Commission, but also that we'll be putting forward proposals to amend the provisions on the substantive crimes, which mirrors the definition and the substantive crimes in Articles 7 and 8 of the Rome Statute. So in essence, we'll be doing the same, engaging in the same efforts, both in the Rome Statute process and the Sixth Committee discussions, and hopefully the convening of the Conference of Plenipotentiaries, so that we address the crime against humanity, slave trade, impunity gap at the horizontal level. So these are the processes, and hopefully I have not bored audience with the UN-related processes. Thank you.
I guarantee you that you have not, Michael, and that it seems to me that there's probably going to be plenty of room for civil society also to weigh in on this issue. Catherine, I want to know, how can you relate this discussion of international criminal law and these very precise international legal instruments, such as the Rome Statute, Crimes Against Humanity Treaty, to your larger work on global reparations? And I want to insert, we have a question that's come in from the comment that has said that the slave trade is in some ways very transnational. So therefore, it might involve many states. Historically, we know that that is true. Would that not also be the question for reparations, or even for a type of complementarity in having the slave trade as a provision in international instruments today?
Absolutely, Patricia. Thank you very much for this very important question. By recognizing slave trade as a crime, in retrospect, you also acknowledge the very basis upon which people of African descent are laying a claim for reparations, because the biggest issue since the Durban Conference against racism is reparation for slave trade and colonialism. So if it's acknowledged today as a crime, then it should have been done so even at Durban and the 400 centuries in which people of African descent underwent the suffering that they did. And secondly, also, Patricia, I think what is important also to acknowledge is that people of African descent were forcibly taken from one jurisdiction to another, where they are still facing the consequences of the deprivation they faced. And so it validates the claim for their current claim. Yeah, I know the US now has HR 40 and the like. So it would make it real that somebody actually owes somebody something, that they contributed for 400 years and there was no pay for their labor, and that accounts for their current state, and not the narratives of laziness and being parasites that we hear. It's that reality that the rich or the currently people that are looking poor, and there is need for these people to be paid now so that we can see an element of justice. So there's that interface between reparation and justice. So you can also say there is an interface between reparation for enslavement and international criminal justice for people of African descent globally.
Thank you. Michael, let me give you a bit of the hot casserole to hold then, since you were talking about state participation, and Catherine has very much linked the two, reparations historically, and potentially reparations based upon conviction. Wouldn't the discussion of these provisions concerning the slave trade possibly have some type of negative effect on certain states who do not want to recognize their historic participation, nor therefore are willing to really engage quite openly in the current need to have the slave trade as a provision, and that might give reparations to current victims of the slave trade?
Thank you so much. And I think this is really an important question, because we really have to drive at firstly addressing the impunity gap. So we have to distinguish the issues of addressing the present impunity gaps which we've explained and the examples we've given in the current modern context, but also the historical context. And this is even where sharing is linked. In terms of the proposal to amend the Rome Statute, in that sense, the Rome Statute system is a self-contained system. So you're dealing with the International Criminal Court, and certainly the implementing legislation that the state parties are under obligation to apply. We note how victims are able to participate in the Rome Statute system and the International Criminal Court, and certainly the court could then order reparation on the basis of the facts presented to them and their findings. So, and for those states that have historical links to the slave trade, they're parties to the Rome Statute. They are under specific obligation in the Rome Statute. So amending the Rome Statute in itself will not present this historical quagmire or challenge, which is present when we look at the horizontal application. Now, in our discussions on crimes against humanity, and particularly the very last cluster, we address this issue about acting on behalf of the victims. And so when we discuss in the present context, and eventually when the Crimes Against Humanity Convention will be adopted, so that's me being very optimistic, we will ensure that states will have in their domestic laws provisions that will allow for reparation, and this could be different forms, not necessarily compensation. This also may not include the historical context, because in the historical context, the conversation is really about the intertemporal principle. And when we refer to the report of this special rapporteur on this issue and how she dealt with, this is Tenda Chumi, how she dealt with the issue of how we need to address this intertemporal principle, which has its place in as we know, the Eurocentric development of international law. This is an issue which we have to face head on. There could be a legal conversation about this, there could be a political conversation about this. But from the legal perspective, it's how we look at the intertemporal principle and its legitimacy in that sense. And in the political context, we see the engagement and activities that are happening and ongoing already. This is not a conversation we'll have in the Sixth Committee, hopefully not in the Rome Statute because it's self-containing, but it's a conversation that is needed at the political level. I do see the potential for the two to be commingled, and I think the onus will be on us, the proponent, and those who are supportive to be able to explain this clearly, that the Rome Statute is self-containing. We have ways to address the plight of victims and reparation in that regard. If we do have the Crimes Against Humanity Convention and state will have obligation to implement domestically, then there has to be provision for reparation for the slave trade crime, as will be the case for other constituent prohibitive act in what is now Article 7 and 8, or in the article that will deal with the substantive offenses in the Crimes Against Humanity Convention. We still have to have that conversation on the historical aspect and how do we address the intertemporal principle in the long run. And this can be done by engagement in the appropriate fora, Sixth Committee, and the political space that is available. Thank you.
Michael, if I hear you correctly, I think you're saying that the proposal for amendments for the slave trade is not a means to avoid a conversation. It might be the means of really having a very just and true conversation that might have historically been lacking, but certainly in our present time is leaving an impunity gap. Well, we have some questions coming in from the audience, and I just want to list two of them and then ask either you or anyone to respond. And one briefly is saying that don't we have to have possibly different jurisdictions today looking at slave trading, but in addition, corporations, that this might be very much of a financial enterprise the reason that slave trade, possibly in MENA, possibly in Libya, occurs today. So isn't the conversation much broader that might include well-resourced companies? Another member of the audience would like to know the difference between the slave trade and human trafficking. I might take that. And then there is that question of intemporality of if the slave trade is a jus cogens norm, it crystallized, but was it legal or wasn't it legal at the time in which the African, let's say, transatlantic slave trade occurred, or even the East African chattel slavery occurred? And I guess the question is, therefore, where does that leave us in terms of historic reparations? Where does that place us, possibly in terms of current provisions in international instruments? Catherine or Michael? You can choose.
I'm happy to go with the question that relates to, I cannot frame it now more properly, but it really calls for the issue of what steps to take with different jurisdiction acting, and how do we reach the legal persons to, if it's a real question of reparation, but essentially compensation, then how do you reach the corporations that may have benefited from slave trade? And I think that would be in the historical context. Now, when we're looking at the state-to-state horizontal level, the two things which we have to address is really criminalization. So we have to criminalize slave trade. And for the Rome Statute perspective, it's ensuring that we have the amendment and then can follow the self-contained Rome Statute provisions and system. So the court and certainly applying the principle of complementarity for domestic action when the state is, willing and able to do so. Once you criminalize, so in the context of the Crimes Against Humanity Convention, if it's adopted, and there's an obligation on states to criminalize. So once you criminalize, the next question is the exercise of jurisdiction. And this can be in various forms, right? And the challenge there would be when you have multiple jurisdictions, you have to determine the closest jurisdiction. So on the basis of so territoriality, as we know, or nationality, and all the other forms of jurisdiction, including universal jurisdiction. We sort of had this conversation in Ljubljana on the MLA provision, because then once you get to the part of victims and reparation and compensation, those states that are really, and this is really a good thing, that are willing to exercise universal jurisdiction, were a bit cautious on the issue of reparation, simply because there's an obligation. Once let's say there's a positive finding, there's a conviction, then how do you deal with reparations? And this will bring into the fore some of the corporations that may be engaged in some of these issues. So in the criminalization process, we also have to ensure that there's a liability for legal persons, so not just individuals, but then liability of legal persons, because this is where, as you would say in criminal law, you have to follow the money. This is where you may get the compensation. You may have some other forms of reparation from individuals, including financial reparation, reparative justice. But in essence, when we think of reparation in the financial sense, it will be reaching legal persons, and this will have to deal with criminalization and the exercise of jurisdiction. Cooperation is important, so that is why I think the Ljubljana Hague Convention is really critical in ensuring state-to-state cooperation in this regard, including cooperation as well with the ICC. Now, on the intertemporal principle, there are exceptions. The challenge of international law, as helpful as it has been in ensuring that we have international cooperation and pursue collective goals in the multilateral legal-based system. When it was developed, most of Sierra Leone, which is now putting forward this proposal, was a colony. And we adopted these principles, including this one, without a voice. And clearly, we've seen that the intertemporal principle is a barrier, a legal barrier, to ensuring that you address the historical context of the slave trade. But there are exceptions. So in the sixth committee, where we progressively develop international law and we codify, the conversation would be, how do we look at this principle from the exception perspective and really deal with the injustice of the slave trade? Thank you.
Thank you very much. Catherine.
Yes, thank you very much, Patricia. I think His Excellency Kanu has really elaborated this very well, because we are now getting into the limitations of codification. What then, if we engage criminal law strictly, will that apply to corporate criminal responsibility, for example? Do we have an established principle to address that? What then again happened to crimes that happened so many years ago, even before the ICC was established? Do we bring them within the jurisdiction? Those are the exceptions he's talking about at this stage. And Patricia, what is very important to note is that when we look at the Nuremberg trials, there was also a bit of retrospective application of this charter. In that crimes were committed, crimes against humanity, the trials happened later, the charter was later, and then it applied to crimes that had already been committed. And it would be very interesting to see how the dynamics play out at this stage, because we have seen also the aspect of racism being a barrier. This is written about by scholars. The aspect of racism has been a barrier to reparations or addressing the legacies of the transatlantic and trans-Saharan slave trade, because we very much know who the victim is and we very much know who the perpetrator is at this stage. And there is a difference between those two. So that is another dynamic, and we would be interested to see how those challenges are overcome in the sixth committee.
Thank you very much, Catherine. I think you brought us several challenges that we have to look at. I'm going to briefly address the issue of the slave trade and trafficking, because these are two different crimes from different jurisdictions that are often conflated. The slave trade is, as we've said before, is an international crime, use, coercion, value, peremptory norms. Trafficking is a transnational crime, meaning that it relates to domestic jurisdiction, but it often happens cross borders. So that's where national states get together and cooperate often with each other, or trafficking could happen within a state. But trafficking is different from the slave trade. Trafficking has different elements. As a matter of fact, it's basically the ability to transport someone by abusive means into a situation of exploitation, whereas slavery or slave trade might be that exploitation. If you're a child, irrespective of whether the means are abusive or not, a child cannot consent to being trafficked. If you're an adult, if you consent and the means are not abusive, you can consent to trafficking, and then that would be a complete defense. To the contrary, consent to the slave trade is legally irrelevant. Whether you consent to be slave traded or not, we're going after the intentions of the perpetrator, much like the intentions of a torturer. And you can't consent to slavery neither. So these crimes are very distinct. Trafficking is not a use coercion violation. As I said before, it's not an international crime, but it is a crime that can be used, we believe, at the complementarity level, that some jurisdictions might invoke trafficking, and in particularly if the exploitation that they're going to then prove is an exploitation of slavery and the slave trading. So I think it's very important to use these different jurisdictional venues, but it's primary of importance not to confuse or conflate the difference between the slave trade and between trafficking. They have different historical objectives and origins. There is another question that's come forward, and Catherine and Michael, you're welcome to answer. The person asked, well, doesn't the slave trade really, or could it amount to the crime against humanity of persecution on the grounds of race? Or is the slave trade a form of the crime against humanity of apartheid? I imagine it's a way of saying either, do we really need the slave trade in addition to persecution or apartheid? Or it could be asking, could we also have the slave trade cumulatively charged or convicted with persecution or apartheid. I hope I'm interpreting the question correctly. Michael or Catherine?
Well, I think I have to use my prosecutorial experience now in distinguishing between prohibitive acts. And so certainly when you're looking at crimes against humanity, the first important element would be the chapeau requirement, right? The widespread and systematic. And then you come to the prohibitive act. And here, really what is significant is the element of the crime. If the elements of the crimes are not the same and they're different in this context, certainly you may use a set of facts to let's say if you're investigating or preferring an indictment, you use a set of facts to prefer indictment on the basis of the prohibitive act and the elements. My appreciation is that the elements are different when you investigate this further. And so in that broader conceptual sense, which is, do we need this amendment and proposal? The answer emphatically from Sierra Leone is yes, we do, because of the impunity gap and what we experience. And I don't see any, so it's not superfluous to have this and also the prohibitive act, which we find in whether in the Rome Statute or the Crimes Against Humanity draft articles. Thank you.
Michael, could I add that even though here we're talking about crimes against humanity, is that Sierra Leone has proposed also that the slave trade be added to the war crimes provision of the Rome Statute, Article 8, and that the war crime of the slave trade is based upon customary law. It is not a grave breach, but we do find it in Additional Protocol 2. And for the International Committee of the Red Cross, it is Rule 94, along with slavery. Slavery and the slave trade are customary war crimes. But there is no war crime of apartheid, and there is no war crime of persecution. So one could argue that the slave trade as a war crime would still be necessary. Catherine, do you have any comments on this?
Other than be in agreement with Honorable Kanu.
That is, I think, a very wise choice that you've just made. But we're starting to approach the end of this webinar. I would like to say first, before turning over final comments to you, is that we hope that it's been helpful for our audience to understand, first of all, that the crime, the international crime of the slave trade exists. It should be alive and doing well in several international instruments. That it is a crime that prevents someone from being reduced into enslavement, and one that prevents the enslaved from being further reduced to situations of enslavement. But it is related to the political processes that Michael has discussed and reparations. I would say even from the historical point of view that Catherine has discussed. I would like to know, could both of you basically not summarize your entire thought process, that would take another webinar, but to tell me whether you think that bringing forward the slave trade at this point in time, when we seem to be in a political era where human rights is facing difficulties, where questions of racial justice are still facing different difficulties, legacies, afterlives of slavery, and where governments might be sensitive both ways. Is this the proper time period to be talking about the slave trade? And the slave trade, I hope, is we come to understand today, both domestic slave trade, internal slave trade, and transatlantic. Catherine?
Thank you very much, Patricia. I think we cannot address the issue of reparations the way we are doing now without properly defining the foundations that have actually laid us here. And one of the key foundations is the slave trade that happened for 400 years and affected people of African descent disproportionately. It's not enough to just be very abstract about it or to avoid the issue. We need to be very specific, and international criminal law is one particular framework or very instructive framework where we can bring this under control. And I think I welcome this endeavor by the government of Sierra Leone to propose the amendment, and I think it's right. It will elevate the political struggle of people of African descent for reparations retrospectively. I say political struggle, but the legal hurdles are an uphill climb that we are yet to overcome. And we need the solidarity of all of us. We need to generate a lot of scholarship around the issues in order to really also elevate our issues as people of African descent. And as humanity, this is a challenge that we face, and the test is right here for us to show whether we have become as civilized as we claim to be. Thank you.
Catherine, let me push you just a bit further, because you've mentioned that there's a role for academics to play in this. Well, then let me ask you, up until now, why has this not been at part of the center of academic discussion? There has been sufficient space taken up on issues of intemporality, whether because of past legality or illegality, and that has been the focus. Why has the focus not been on slave trading today, as you mentioned, with domestic workers in the Middle East or in Brazil, or understanding that child soldiers are slave traded children? Why haven't academics looked at that perspective that occurs today and relating it back to reparations?
This is an insider challenge, Professor Sellers, that we are facing as academics in terms of who is writing what. That is one perspective. Here we have established an Africa Reparations Hub, and we are looking at the issues from the perspective of Africans. And it has become necessary for Africa to write from its own perspective. So people of African descent are encouraged to write scholarship from their perspective. It has become important to speak for ourselves. So it has been the point of who is writing. I'm sorry to say that, but who is writing? So as scholars of African descent begin to rise, then we are seeing more of these views also coming forward, in parallel with what has been in the mainstream scholarship. And this comes also with the rising of call for reparations that has become more justifiable in the recent past, that there can never be justice without reparations for people of African descent.
Thank you. Michael, I turn to you for final words, please.
Oh, well, thank you again for really not only moderating the session, but really being the critical voice that is leading work on this, including your role at the ICC, but your academic contribution as well, and to all of the colleagues who have been engaged in this. And I also want to thank Catherine for really your important and valuable contributions this afternoon. When you were asked the second question by Patricia, I think the point also is about, as you say, well, I had two comments. Firstly, it's about, as you say, who's writing and who is not writing. And there could be very good reason for those who are not writing, including the role of states to provide the avenue for those who are not writing to engage in that space. And that's the recognition I think we've gotten from you today, in the sense that we open up the space for that engagement, and I'll come back to that point. Now, from the general United Nations perspective, Patricia, when you introduced me, you mentioned that I coordinate the African group on the BBNJ process. When the BBNJ treaty or agreement was adopted, we saw it as a huge and big win for the multilateral system. And following that, there were really successful engagement on other multilateral processes, including the MLA Convention. So we think that the time is ripe and right for constructive engagement on difficult topics in the multilateral system. From our perspective, once we realize that we are sunsetting the assessment of the independent expert recommendations relating to the ICC, it's also a good opportunity to put forward the Rome Statute a proposal, because we'll have the time and space to really have a robust and constructive engagement. So we feel very optimistic in terms of the processes from the UN perspective. But politically, there's a reckoning relating to the historical context of slavery and reparation. So it's also the time to have this discussion. It's difficult, but we've had from studies that have been undertaken, yes, we'll question who will do the study and collaboration, but from the Crown in the United Kingdom, for example, to those specific academic institutions that would have found this really difficult to engage, including in the United States, on the slavery issue. We've seen how progressive some universities have been, despite the political conversation. So we think, as difficult as this may be, the time is right. And so the next step would be support from those member states that's quite supportive of the issue, including African states, states in CARICOM states, states from Latin America, but also European states that have taken a really progressive approach to this. So we want to hear those supportive voices, that's one. Civil society, in the discussions in the Sixth Committee, in the ICC process, which is quite open and inclusive, we want to hear the supportive civil society voices. Please join a border coalition. We don't want to lead this alone. We're building a coalition of states, group of friends to ensure that we have critical mass in putting forward this important proposal. We cannot do this without civil society, so please jump on board. Academia as well. We hope to have an event in the Rome Statute 25th anniversary to continue this conversation, and also host a series of events eventually before we get to December, and hopefully next year, where we hope we'll adopt the proposal. So we feel positive, and we hope that for those of member states and civil society organizations that are supportive of this, please join us in this broad coalition. Thank you.
Well, thank you both, Michael and Catherine, for being our wonderful panelists today. And I would have to say, of course, I am completely prejudiced that, yes, this is the time. 100 years from now, would that be better? The only time that would have been better was 100 years ago. And so if we are going to reach for a new treaty about crimes against humanity, or to look at the Rome Statutes, Article 7, crimes against humanity, I would ask the question, who is humanity other than us to place these provisions within the Rome Statute and the future Crimes Against Humanity Convention that will govern our humanity as we go forward in the future. Thank you so very much. And I would really like to thank the audience, the questions we didn't get to, but in particularly the hearts and minds that stayed with us throughout this webinar. Thank you and goodbye.